Calling the case of the state of Michigan versus Jamaran Hardman. This is case 250754FY. This is date and time set for an appearance or for an arraignment. Appearances for the record starting with the people.
Good afternoon, Your Honor. Devin Schultz on behalf of the people.
Defense.
Good afternoon, Your Honor. Edward Hess on behalf of the defendant for this afternoon's proceeding only. Mr. Hardman, please state your name for the record.
Jamaran Hardman.
Thank you, sir. Your Honor, I have reviewed the charges and maximum penalty with Mr. Hardman. At this time, we'll waive any further formal reading by the court. Mr. Hardman pleads not guilty, and he's requesting court-appointed counsel. Thank you.
Okay. Court's going to enter a plea of not guilty. Court-appointed counsel is granted. Sir, your case has been assigned to the Honorable Judge Gross. It is a felony. Because it is a felony, there are two hearings that are scheduled for this case. The first is called a probable cause hearing. It will be held on June 17th, 2025. That's going to be at 1:30 p.m. on Zoom. The second hearing was what is called a preliminary examination. It'll be held on June 24th, 2025. That will be at 9 a.m. in person at the 50th District Court. Do you understand that, Mr. Hardman?
Yes, ma'am.
Okay. As it relates to bond, Ms. Schultz, people first.
Thank you, Your Honor. I want to provide a little bit of information about this case to Your Honor because the people at this time are requesting at least a $150,000 cash surety bond with no 10%. On January 3rd, this week, there was a graduation at the United Wholesale Mortgage Sportsplex in Pontiac, and that was for the Academy of Arts and Technology for Pontiac. Mr. Hardman was in attendance along with his co-defendant, Mr. Whaley, and two other unidentified individuals. They walked into the auditorium of the Sportsplex, they took a seat, and they were only inside for less than 10 minutes before Mr. Hardman, Mr. Whaley, and the other two suspects approached another group, and Mr. Hardman struck another young man in the head who was in attendance at the graduation. The fight escalated. They were escorted out. Another fight began at the entrance of the Sportsplex, and then everybody was taken out into the parking lot. At this point in time, Mr. Hardman and Mr. Whaley began to congregate around a vehicle, a Hyundai Elantra. Mr. Hardman at some point walked away from that vehicle where he appeared to be intentionally struck by a Chevy Malibu. He was uninjured and he returned to the group. Surveillance video from the parking lot shows that at that time, Mr. Hardman became in possession of a very distinctive graphic printed with a shark on it backpack, and he was now standing by an open Elantra. The video also shows that at this time, the co-defendant, Mr. Whaley, is running back towards the group, now clutching his waistband with a heavy object. At one point in time, his shirt rides up, and you're able to see clearly on the surveillance footage that Mr. Whaley has what appears to be an extended magazine sticking out of the waistband of his pants. Mr. Hardman and Mr. Whaley run through the parking lot for a brief period of time, and then they enter back into the Elantra. The whole time, Mr. Hardman has possession of this very distinctive backpack. The Elantra drives through the parking lot for a short period of time, and then Mr. Hardman and Mr. Whaley exit it again. At this point in time, Mr. Hardman, still with the backpack, and Mr. Whaley crouch under and in between some parked cars in the parking lot. They get back into the Elantra and they leave. Less than 20 minutes later, deputies with the Oakland County Sheriff's Department discover two firearms right where Mr. Hardman and Mr. Whaley were crouching. They discover a Glock with an extended magazine just on the pavement underneath a vehicle. They also discover the same backpack that Mr. Hardman was in possession of. Inside of that backpack, they find an AR-style pistol and a drum magazine. Both firearms had the capacity to be loaded with 40 rounds of ammunition and were nearly fully loaded, and both had a round chambered. Mr. Whaley was interviewed post-Miranda. He admitted to possessing a firearm. He stated that he left it in the car, the Elantra presumably, during the graduation ceremony, and then retrieved it after the incident where Mr. Hardman was struck with a car. Mr. Hardman was interviewed and denied everything and denied that there was a firearm in the backpack. What I want to highlight for Your Honor and why $150,000 is justified for bond for Mr. Hardman is that he is at this time 70 days into a HIDTA probation term for carrying a concealed weapon out of the Oakland County Circuit Court. That case happened in May of 2024 last year. He was sentenced on March 31st of this year before Judge Rowe, And over the people's objection, Judge Rowe gave him a chance on YTA. And he gave him a chance on YTA with a set of very strict conditions, which Mr. Hardman, not including new criminal conduct, has already continued to violate. He was ordered not to be around known felons. The people have Instagram evidence that he's been hanging out with individuals who are known felons and, in fact, on federal supervised release. He was ordered not to return to a smoke shop where a number of music videos were shot that's located in Sterling Heights. This same location was the subject of a bond motion, one of multiple, during Mr. Hardman's time before Judge Rowe, that he was ordered not to return to explicitly. He was already posted within weeks of being placed on probation in a music video at that same location. On top of that, during the time that Mr. Hardman was pending in circuit court before Judge Rowe, we had multiple issues with bond. There were unauthorized stops. He was on a tether. That didn't deter him from being what he needed to do. He was found in another defendant's phone dump for a separate assault with intent to murder case, looking for where he could get a firearm. And this was during October of 2024, so well into the time that his case was pending. He repeatedly posted images of marijuana, references of selling marijuana, and driving around and not following directives from the court, both district court, Judge Bowie and Judge Rowe, to engage in meaningful employment, to follow a curfew, and to be where he's supposed to be. The reality is that Mr. Hardman is only 20 years old, and he now is facing his second weapons offense, a second felony weapons offense. Not only this, but he does have a juvenile adjudication for domestic violence. Mr. Hardman has demonstrated time and time again that he cannot and he will not abide by any condition that any court in Oakland County sets for him at any stage of proceedings. He has had his bond increased. He has had a tether on him. He has had very strict parameters on what he can and cannot do. He has been given chances by the court. None of them have deterred Mr. Hardman from less than 3 months into a probationary term for a weapons violation from not seeking out and possessing another weapon. This graduation, Your Honor, was a public event. There was over 1,000 people registered for attendance. Mr. Hardman already disrupted that event with physical violence inside of the auditorium. He is the instigator. This is on video. But not only that, but instead of walking away, instead of leaving after he was escorted out, Mr. Hardman and his co-defendant escalated. They took this a step further by arming themselves, presumably in response to the Chevy Malibu incident. The people are asking for a bond that is going to ensure the protection of the public, that is going to reflect the serious nature of this offense, and that is going to, frankly, protect Mr. Hardman himself. He has shown that he was willing to instantly engage in retaliatory behavior against other individuals who were at the graduation ceremony. He was armed with a firearm that day that had the capacity to shoot 40 rounds. He took that firearm to that location and then armed himself with it after the Chevy Malibu incident. Mr. Hardman is willing to engage in dangerous behavior. He does not care about the collateral consequences of public safety, and no court directives have ensured his compliance while on pretrial release, including a term of YTA probation. So for all of those reasons, I'm asking for at least a $150,000 cash surety, no 10% bond, no tether. Thank you.
Thank you. As it relates to this bond, pretrial services, what is your recommendation? And then I'll get to defense.
Thank you. The defendant was interviewed. His information was verified by his mother, Shantonika Burns. He's a single 20-year-old male with no custody of a 1-year-old child, indicated living at the stated address for a few months with his grandmother. Appears to be, or reported being unemployed for, quote, a while, high school graduate, as stated by the prosecutors, on probation at the time of the incident. He's also been on several community-based programs, including the Step Forward program. I can verify that there has been numerous issues of non-compliance while on community-based programming with pretrial and justice services. I can also verify that he's been on tether and has had similar incidents of non-compliance while on tether. I would add to what was stated, in addition to the incident that was suppressed with HIDA, there was one prior incident that the warrant was denied previously. Given all the above information stated, we are not recommending release on recognizance. We would recommend pretrial supervision, no firearms, other dangerous weapons, no assault or threatening behavior, no contact with the co-defendant, Mr. Whaley, and a GPS tether prior to release, no return to the location of the incident. Thank you.
What is the location, the address for the location of the incident?
I don't have it readily available. I'm not sure if the prosecutor's office may have it at hand.
Just a moment, Your Honor, I can look it up.
Okay, while you look that up, defense, your rebuttal?
Yes, thank you very much, Your Honor. In considering the bond to be granted in this matter, the court has to consider the protection of the community, and their person, and the likelihood of Mr. Hardman returning to court. So as far as returning to court, I haven't heard about a prior failure to appear history. There is there's a recommendation in the written pretrial services report for a home confinement tether. I think that's an appropriate condition of release that would be able to satisfy the community safety aspect of release without having required a high cash surety bond. I will also note some positives for my client. He indicates to me he is in community college. He has been hired for a job at a factory that he would like to start soon. And as a concern, he also does have a medical issue that requires physical therapy. So he is seeking to be released for that reason as well. So I respectfully ask that if the court finds that my client is not a good candidate for release on recognizance, that any bond imposed be a 10% bond with appropriate conditions to include a GPS tether with home confinement, as opposed to requiring a high cash or surety bond with confinement in the jail. Thank you.
Counsel, does your client,
Honor.
does your, one second, defense, 1 second, Madam Prosecutor. Defense counsel, does your client own his own home?
I don't believe so, Your Honor.
Okay. People, you had something to
Thank you.
say?
Yes, Your Honor, I had a very brief response if you'd allow it. I also have the address for the
Give me the address.
location of the graduation. It was 867 East
Mhm.
South Boulevard, and that's in Pontiac.
Thank you. Your rebuttal?
Yes, thank you, Your Honor. I want to address two things. The first being
Hold
that-
on 1 second. I need 1 second with my. Thank you. Your rebuttal.
Thank you, Judge. Your Honor, I want to address two things here. The first being that this isn't a situation where we're worried about Mr. Hardman appearing for a court date. What we're worried about is what Mr. Hardman is up to when he's not appearing in court, and when he thinks the court is not watching, and when he thinks the court isn't able to track what he's doing. He has demonstrated for over an entire year at this point to the Oakland County Circuit Court and to the Oakland County District Court at the pendency of his first case that he will not abide by the terms and conditions set by the court, and that he will only address them when he is brought before the court for a bond motion and thinks that it's going to have a negative impact on him. He has continuously violated, as pretrial services stated, throughout the course of a year. So respectfully, I don't think that the analysis is whether or not he's going to appear for court. The analysis is whether or not we can protect the public now from Mr. Hardman, who has demonstrated that he can and will continue to access weapons regardless of the fact that he has a pending felony probation. I also want to address the argument that home confinement would be suitable to protect the public. In this case, I respectfully disagree. As I stated, the people were in receipt of a phone dump in a separate case, an assault with intent to murder, in about October of 2024, where Mr. Hardman is texting and communicating with that group, talking about sliming his opponents out, talking about engaging in acts of threats or violence with other people in the community, and talking about where to find a firearm. So I think that home confinement does nothing to tell us what Mr. Hardman is saying to other members of the community. It does nothing to tell us about what he's planning. And it really does nothing to prevent the coordination of him accessing another weapon. Finally, I just want to address the point of the medical condition with the physical therapy. Mr. Hardman did raise this issue in June of last year before Judge Bowie. This has been brought up multiple times. It was my understanding from every bond motion we've had that that has never been something that was prohibitive of him. In fact, then going to find work and saying he was going to find work when the court told him to. So when we consider all of these things, Your Honor, I think it's clear that at this point in time, Mr. Hardman's behavior is what has Mr. Hardman before the court today. And it is his behavior that is dictating the people's request here for a high cash surety bond with no 10%. The public cannot be protected from him. He will not abide by court orders. And this is a severe set of facts that could have caused serious injury to many people. Thank you.
Thank you. When the court weighs its decision as to what the bond will be, there are a couple things we have to consider. One is the safety to the community. Two is the likelihood of the defendant returning to court, and then also whether or not this defendant will comply with this order. My review of the defendant's record and the complaint in this case indicate that it's not very likely that the defendant will comply with this court's order. For that reason, court is imposing a $250,000 cash bond with the following conditions. Pretrial services supervision. Sir, when you are released on this bond, there's a blue piece of paper that's the size of this. It'll have the instructions for you to contact pretrial services. It will also, you're also ordered to have no contact with the co-defendant, who is indicated as Devin Whaley, DeAhveon Whaley. Sir, if you are released, you will be placed on a GPS tether prior to release, and that's going to be the steel band tether. And there's no return to 867 East South Boulevard in Pontiac, Michigan. Mr. Hardman, do you understand the terms of your bond?
Yeah.
Okay, do you have any questions about your bond, sir? Okay, then you can stand, Mr. Hardman. Go to that door behind you, push out, and let them know we're ready for the next defendant. Thank you, sir. Okay, calling the case, people of the state of Michigan versus I'm gonna mess up. Davion Whaley. This is case 250753FY. Date and time set for appearances. Appearances for the record. People first.
Good afternoon, Your Honor. Devin Schultz on behalf of the people.
Good afternoon. Defense.
Court has on behalf of Mr. Whaley for this afternoon's proceeding only. Mr. Whaley, please state your name for the record.
Davion Whaley.
Thank you, Your Honor. I've had the opportunity to review the charges and maximum penalties with my client. This time will waive a further formal reading by the court. My client pleads not guilty, and he's requesting court-appointed counsel.
Okay, thank you. I'm going to enter a not guilty plea on behalf of your client. I am granting court-appointed counsel going forward. Sir, your case is a felony. It's been assigned to the Honorable Judge Gross. There are two hearings that are coming up. The first is called a probable cause conference. It will be held on June 17th, 2025. That's going to be at 1:30 p.m. on Zoom. The second hearing is a preliminary exam. It'll be held on June 24th, 2025. That's going to be at 9 a.m. in person. As it relates to bond, people.
Yes, thank you, Your Honor. I am not going to belabor the point of all of the facts because I know Your Honor is familiar with them from Mr. Hardman's arraignment just moments ago. But what I want to highlight for Your Honor is that Mr. Whaley is on video on June 3rd after being escorted out after this fight broke out at the ATAP graduation with a firearm with an extended magazine in his waistband. This is visible on the surveillance video. That same firearm is recovered less than 20 minutes after Mr. Whaley is observed crouching down in between vehicles after presumably ditching the firearm. And it turns out to be a Glock with an extended magazine. There's a round in the chamber, and it has the capacity to hold up to 40 rounds. If I recall correctly, it had 38 rounds in it at the time. This gun was ready. It was loaded. It was good to go. Mr. Whaley was interviewed in post Miranda. He did admit to possessing that firearm. He admitted that he did not bring it into the graduation, but instead that it was in the car, the Hyundai Elantra that we discussed when we were going over the facts previously. He stated that he went and grabbed that gun after the incident where his co-defendant, Mr. Hardman, was struck by the Chevy Malibu. But I want to point out something else, to your honor, which is that Mr. Whaley also told investigators in this case that he had that gun in the car and went to the graduation knowing there would be people there he didn't like. And so what I want your honor to take away from that is that in a situation where Mr. Whaley believed there was going to be people that he didn't like, didn't get along with, possibly could have a confrontation with, he brought a loaded weapon with nearly 40 rounds in it. And he had that ready to go. Mr. Whaley's only 19 years old. He's already before the court for multiple weapons violations. He also has a juvenile adjudication from only 2023 for an armed robbery and a felony firearm. And it's my understanding that the facts of that case arise from a robbery of a weed dealer, where a firearm was not only displayed, but in fact fired off into the sky during the course of the robbery. Mr. Whaley was sentenced to what I understand to be the most restrictive juvenile adjudication. He was dispositioned and sent to the Boys Treatment Program. He successfully completed that program. He was only 18 and a half at that time. But your honor, as you can see, the completion of that program, having a very, very serious, what would have been a capital case had he been an adult, felony firearm armed robbery case, did nothing to deter Mr. Whaley from getting out. When he turned 19, he again had access to firearms. He had a firearm. He brought it to this graduation, and his conduct has not changed. So for all of those reasons, I'm again asking your honor for at least a bond of $150,000 cash. I don't think that a tether is going to be appropriate in this case. This is a situation where, again, this was a public event where Mr. Whaley, for whatever personal problems he had with people attending there, decided to bring a high capacity firearm. He is a danger to the public. He's demonstrated that he would be willing to engage in retaliation by immediately arming himself after the Chevy Malibu incident in the parking lot. He didn't care about the collateral consequences of either a fist fight or then arming himself and attempting to run through the parking lot, presumably in the direction of the Chevy Malibu. Mr. Whaley is a danger to the public. He is a danger to himself. And while this may be his first adult case, it is a serious one nonetheless. And the charges shouldn't belie the seriousness of the actual facts underlying the case. So for all of those reasons, I'm going to ask that you impose a bond of at least $150,000 cash. I do not think a tether would be appropriate to ensure Mr. Whaley's behavior in the public or safety to the public. Thank you.
Thank you. Pretrial services, your recommendation?
Thank you. The defendant was interviewed. His information was verified by his father, Lester Whaley. He's a 19-year-old single male with no children. He's been living with his father and grandparents at the stated address for 5 months. He's employed full-time with American Axle as a machine operator, high school diploma. He's not currently on community supervision, has a limited criminal history. As indicated, he does have a juvenile history. He's before the court on serious felony offenses. Therefore, we are not recommending release on recognizance. The author of this report is recommending pretrial supervision, no firearms or other dangerous weapons, no assault with threatening behavior, no contact with his co-defendant, Jamaran Hardman, and I would add no return to the UMW Sports Complex at 867 East South Boulevard in Pontiac, and they indicated a GPS tether prior to release. Thank you.
Thank you. Defense.
Thank you, Your Honor. This young man is gainfully employed, lives in a stable housing situation with his family in Pontiac. I would respectfully ask that following the written recommendation, the Pretrial Services Department for a GPS tether with home confinement, that the court find that a 10% bond would be appropriate if releasing recognizance is not appropriate. So I'd ask for a 10% bond and GPS tether with home confinement. I think that would serve the interest of protecting the community and also allow the court to ensure my client's location and to ensure his return to court. Thank you.
Thank you. You have a rebuttal, Ms. Schultz?
Yes, briefly, Your Honor. I just want to highlight, by all accounts, Mr. Whaley had everything going for him. If he was gainfully employed, he completed his services for the armed robbery when he was a juvenile, and he had stable housing, and yet he still possessed a Glock with an extended magazine and brought it to a public event. He still armed himself with it. He has demonstrated that he is a danger to the public, and my request still stands, and I would ask for no 10%. Thank you.
Thank you. Court has to take into consideration the safety and well-being of the community, as well as whether or not the defendant will appear. And then in addition to that, this court likes to consider the actual allegations and whether or not this defendant will comply. This is an incident where the defendant, you said at 18 and a half, successfully completed a juvenile program where he avoided incarceration for armed robbery and felony firearm, completed a number of courses, and it appears once he was released, he was gainfully employed, placed into a stable household, and now we have these allegations pending involving dangerous weapons, yet again in a public place this time. Court is going to impose a $200,000 cash bond. Should you make that bond, sir, you're going to be supervised by pretrial services. They're going to give you this blue piece of paper. On it has the pretrial services phone number. In addition to that, you're to have no contact with the co-defendant, indicated to be a Jamaran Hardman, no further assaultive behavior that includes while in jail, no firearms and or any other dangerous type weapons. Should you be released, we're doing GPS tether, steel band, no return to the address of the alleged incident, which has been identified as 867 East South Boulevard in Pontiac, Michigan. Mr. Whaley, do you have any questions concerning the terms of your bond?
No, ma'am.
Okay. If you don't have any questions, sir, you can stand, go to that door behind you, push out, and let them know we're ready for the next person.